If you're holding two passports right now or you're planning to acquire dual citizenship, stop everything you're doing and listen carefully. October 2025 is bringing a seismic shift to U.S. dual citizenship policy that could completely reshape your rights, your tax obligations, and even how your American citizenship is legally interpreted. This isn't just another minor policy tweak. We're talking about changes that could impact millions of Americans living abroad and those maintaining deep connections with their countries of origin. By the end of this video, you'll understand exactly what's coming, why it matters, and most importantly, what you need to do right now to protect yourself. So stay with me until the very end because missing this information could cost you dearly. Hey everyone, si monsteru once. Welcome back to World Discoverer Hub. I'm here to break down the most critical immigration and citizenship news that directly affects your life. If you're new here, this channel is your trusted source for navigating the complex world of U.S. immigration law, visa regulations, and citizenship matters. We cut through the confusion and give you clear, actionable information you can actually use. Today's topic is particularly urgent. We're diving deep into the sweeping changes to dual citizenship regulations that the U.S. government is rolling out. These aren't small adjustments. These are fundamental shifts in how America views and manages dual nationality, touching everything from your tax responsibilities to your passport renewal process, from your voting rights to your career opportunities in federal service. Whether you were born with dual citizenship, acquired it through naturalization, or you're seriously considering obtaining citizenship in another country, this video is absolutely essential viewing. I'm going to walk you through every major change, explain what it means in plain English, and give you concrete steps to prepare. So, make sure you hit that subscribe button and turn on notifications so you never miss critical updates like this. Trust me, you'll want to stay informed as these changes unfold. Let me set the stage by giving you some essential context. For decades, the United States has maintained what many would describe as a somewhat paradoxical relationship with dual citizenship. Now here's the interesting part. The United States government doesn't actively encourage or promote holding citizenship in multiple countries. In fact, if you look at the official stance, there's a clear preference for single allegiance to the United States. However, and this is crucial, the reality on the ground has been quite different. The United States has tolerated and effectively recognized dual nationality under specific circumstances, creating a practical framework that millions of Americans have operated within for years. Think about the naturalization ceremony. When individuals become United States citizens through naturalization, they stand before an official and recite an oath. That oath includes language about renouncing allegiance to any foreign prince, potentate, state, or sovereignty. It sounds pretty absolute, right? The words are clear and unambiguous. You're declaring that your loyalty now belongs exclusively to the United States. But here's where theory and practice diverge significantly. Despite that solemn oath, the United States government has not actively required people to physically surrender their foreign passports or formally renounce their other citizenships. Many naturalized Americans continue holding their original passports, traveling on them, and maintaining full citizenship rights in their countries of birth, all without facing any consequences or penalties from United States authorities. The same flexibility has extended to individuals born with dual citizenship. Picture this scenario: a child born in the United States to one American parent and one parent who's a citizen of another country. That child often automatically receives citizenship from both nations at birth. For decades, these individuals have been able to maintain both passports, enjoy rights and privileges in both countries, access education systems in either nation, work in both places, and essentially live with a foot in two worlds without encountering significant legal obstacles or government interference. This practical tolerance has created a substantial population of dual citizens. We're talking about millions of Americans who have built their lives, their careers, their family structures, and their financial plans around the assumption that this flexibility would continue indefinitely. Many have purchased property abroad, established businesses in their countries of origin, maintained bank accounts in multiple jurisdictions, and created complex international lives that span continents. But as we approach October 2025, that entire landscape is about to transform dramatically. The era of relative flexibility and lenient oversight is coming to an end. The United States government has announced a comprehensive overhaul of its dual citizenship policies, implementing stricter regulations, enhanced monitoring systems, and significantly more rigorous enforcement mechanisms. So, what's driving this major shift in policy? The government has outlined several key motivations. First and foremost is national security. In an increasingly complex geopolitical environment with rising tensions between major powers and growing concerns about foreign influence, so greater clarity about where dual citizens' loyalties lie. There's heightened concern about potential conflicts of interest, especially when dual citizens work in sensitive positions or have access to classified information. Second, there's the issue of tax compliance. The United States has one of the most aggressive tax systems in the world when it comes to its citizens abroad. America taxes based on citizenship, not residency, which really sets it apart from nearly every other nation. This means that if you're a United States citizen living in Tokyo, London, Dubai, or anywhere else on the planet, you're still required to file United States tax returns and potentially pay United States taxes on your worldwide income. The government believes that dual citizenship has created opportunities for tax avoidance, with some individuals strategically using their multiple nationalities to obscure income, hide assets, or exploit gaps in international tax treaties. Third, there's a push for greater international transparency and cooperation. The United States wants to strengthen its ability to track cross-border financial flows, combat money laundering, prevent terrorist financing, and honestly, ensure that American citizens aren't using their dual status to circumvent laws or regulations. This aligns with broader global initiatives around financial transparency and information sharing between governments. Now let's get into the specific changes that are coming in October 2025, starting with what's probably going to hit dual citizens hardest in their daily lives: taxation and financial reporting requirements. The United States already has what many consider to be one of the most demanding tax systems for citizens living abroad. Through FATCA, the Foreign Account Tax Compliance Act, and various other regulations, Americans overseas must report their foreign bank accounts, disclose foreign assets above certain thresholds, and navigate a complex system of forms and filing requirements. Many dual citizens have found this burdensome but manageable, often with the help of specialized tax professionals who understand both U.S. law and the tax systems of other countries. Starting in October 2025, the IRS is significantly ramping up these requirements. The new regulations will mandate much more detailed disclosure of foreign assets. We're not just talking about bank accounts anymore. The enhanced reporting will cover foreign investments of all types, including stocks, bonds, mutual funds, and retirement accounts held abroad. So, it will extend to real estate holdings, requiring detailed information about properties owned in other countries, including rental income, property values, and any mortgage or financing arrangements. Business interests will come under greater scrutiny, with dual citizens needing to provide comprehensive information about any foreign companies they own, partially own, or have significant control over. The threshold amounts that trigger reporting requirements are being lowered in many categories, meaning more people will be caught in the reporting net. The forms themselves are being revised to request more granular information, including the sources of funds used to acquire foreign assets, the beneficial owners of any foreign trusts or foundations, and detailed transaction histories for significant asset movements. But here's where it gets even more serious. The penalties for non-compliance or incomplete reporting are being substantially increased. Previously, if you made an honest mistake or overlooked something on your foreign asset reporting, the penalties, while significant, were often negotiable, especially for first-time offenders who could demonstrate good faith efforts to comply. Under the new regime, the IRS will have much less discretion. Automatic penalties will be assessed for missing information, Even technical violations could trigger substantial fines, and the burden of proof will shift more heavily onto the taxpayer to demonstrate that any omission was unintentional. The IRS is also receiving enhanced tools for enforcement. Through expanded international cooperation agreements, the agency will have better access to foreign financial data. Banks around the world are increasingly required to report information about American account holders directly to the U.S. government. This means the IRS will often know about your foreign accounts before you report them, and any discrepancies between what you disclose and what they already know can trigger immediate red flags. For dual citizens, this creates a new reality. You can no longer afford to be casual or approximate in your tax reporting. Every foreign account, every overseas investment, every piece of foreign real estate needs to be meticulously documented and accurately reported. The days of hoping that the IRS won't find out about your bank account in your country of origin or that small apartment you inherited from your parents are essentially over. This also has implications for tax planning and financial decision-making. Dual citizens will need to think much more carefully about where they hold assets, how they structure their investments, and the tax consequences of financial decisions in both countries. What might be a tax-efficient strategy in one country could create massive headaches with the IRS, and vice versa. This is why professional advice from tax specialists who understand both systems becomes not just helpful, but absolutely essential. Let me move on to another major area of change passports and documentation requirements. The U.S. State Department, which oversees passport issuance and management, is implementing enhanced verification protocols specifically targeting dual citizens. Currently, when you apply for or renew a United States passport, the process is relatively straightforward. If you already have a previous passport or clear documentation of your citizenship, you submit your application, provide the required photos and documentation, pay the fee, and, in most cases, you receive your new passport without much additional scrutiny. That's changing significantly. Starting in October 2025, dual citizens will face more comprehensive documentation requirements when dealing with passport applications or renewals. The State Department will require more extensive proof of your ongoing ties to the United States and your residential status. This might include, multiple years of tax returns demonstrating that you've been filing as required. They may also request proof of U.S. residence even if you live abroad, such as property ownership records, utility bills, or rental agreements showing you maintain a home base in America. Employment records showing work for U.S. companies or evidence of ongoing economic ties to the United States could be requested as well. There's a particular focus on individuals who hold passports from countries that the U.S. government considers high risk, or with which the United States has strained diplomatic relations. If your second citizenship is from a country that's on any U.S. watch list, has limited diplomatic ties with America, or is seen as potentially adversarial, you should honestly expect additional scrutiny. You may be asked to provide extensive documentation proving your genuine connection to the United States and demonstrating that your primary allegiance remains with America, even if you hold another passport. The application process itself will likely take longer for dual citizens. Where a typical passport renewal might take a few weeks, dual citizens should budget for several months, especially if you're flagged for additional review. This has practical implications. If you need to travel, and your passport is expiring, you can't wait until the last minute. You need to plan well in advance and leave substantial buffer time for processing. Now let's talk about something that hits at the very heart of citizenship, the oath of allegiance. For those who become U.S. citizens through naturalization, the naturalization ceremony is a profound moment. You're welcomed into the American family, granted all the rights and responsibilities of citizenship, and you take an oath committing yourself to your new country. The government is revising the language and interpretation of this oath. The updated version will place even stronger emphasis on exclusive loyalty to the United States. Now this is nuanced, so let me be very clear about what this means and what it doesn't mean. The revised oath does not automatically require you to physically surrender your other citizenship or formally renounce your foreign nationality through your other country's legal process. That would be extremely controversial and face significant legal challenges. What it does is create stronger legal grounds for the expectation that your primary allegiance, your ultimate loyalty, must rest with the United States. In practical terms, this means that if conflicts arise between U.S. interests and the interests of your other country of citizenship, you are expected to prioritize American interests. If your actions are seen as actively supporting a foreign government in opposition to U.S. policy or U.S. security interests, those actions could now trigger a formal review of your citizenship status. This is serious. We're talking about potential denaturalization proceedings in extreme cases where the government could theoretically move to revoke your U.S. citizenship if they believe you've violated the fundamental principles of allegiance. This doesn't mean you can't visit your country of origin, maintain cultural connections, or even advocate for policy positions that might benefit that country. What it means is that there are clearer red lines about activities that would be considered inconsistent with your oath of allegiance. Working for a foreign intelligence service, taking a position in a foreign government that involves policy opposition to the United States, or engaging in activities that could be construed as supporting foreign interests against American interests, would all potentially trigger scrutiny. For individuals born with dual citizenship, you didn't take a naturalization oath, so these specific changes don't apply to you in the same way. However, you're not exempt from increased oversight. The new regulations introduce additional background check requirements for dual citizens seeking positions in sensitive sectors. If you're applying for federal employment, especially in agencies dealing with national security, defense, intelligence, law enforcement, or diplomatic services, expect much more rigorous vetting. These background checks will go deeper into your connections with your other country of citizenship. Investigators will look at your travel patterns. Do you spend significant time in your other country? They'll examine your financial ties. Do you have substantial assets, business interests, or income sources there? They'll review your family relationships. Do you have immediate family members who work for that country's government or military? They'll assess your communication patterns and social connections. Being a dual citizen won't automatically disqualify you from these positions, but it adds a layer of complexity to the vetting process. You'll need to be completely transparent about your foreign connections, prepared to answer detailed questions about your loyalty and allegiance, and possibly willing to accept certain restrictions on your activities or travel as a condition of employment in sensitive roles. The Department of Defense is taking this particularly seriously when it comes to military service. Dual citizens have long served honorably in the United States Armed Forces, bringing diverse perspectives, language skills, and cultural knowledge that enhance military capabilities. However, the Pentagon is re-evaluating its policies regarding where and how dual citizens can serve. New rules being implemented may restrict the deployment of dual citizens to certain geographic regions, particularly if their secondary nationality is from a country with adversarial or strained relations with the United States. Imagine you're a dual United States-Iranian citizen serving in the military. Under the new policies, you might be restricted from deployments to the Middle East or from positions that involve classified intelligence about Iran. Similarly, a dual United States-Russian citizen might face limitations on European deployments or assignments involving NATO operations. These restrictions aren't meant to question anyone's patriotism or dedication to service. They're driven by security concerns about potential conflicts of interest, the risk of coercion if you have family in your other country of citizenship, and the complications that could arise if you were captured or detained while serving in a region connected to your other nationality. For service members who maintain dual citizenship, this could have significant career implications. Certain career paths, especially those involving special operations, intelligence work, or assignments in sensitive geographic regions, might become limited or entirely closed off. This is something that current service members and those considering military service need to carefully evaluate as these new policies take effect. Another evolving area, and this one is still somewhat fluid, involves political participation and eligibility for public office. Let me be clear up front. Dual citizens retain their fundamental right to vote in United States elections. That's not changing. Your ability to cast your ballot in federal, state, and local elections remains protected regardless of your dual citizenship status. However, there's growing debate, particularly at the state level, about whether dual citizens should be eligible for certain public offices or advisory positions. Some states are exploring legislative proposals that would restrict dual citizens from serving in specific roles, particularly those involving security clearances, access to classified information, or significant policymaking authority related to national security or foreign relations. These are not federal rules yet, and it's unclear whether such state-level restrictions would withstand legal challenges. There are serious constitutional questions about whether states can impose additional citizenship requirements beyond what federal law establishes. But the fact that these conversations are happening reflects a changing political climate around dual citizenship and growing public discourse about potential conflicts of interest. And at the federal level, while there are no outright bans being proposed, there's increased scrutiny of dual citizens seeking appointments to certain positions. Presidential appointees with dual citizenship can expect more intensive vetting, more detailed questions during confirmation hearings if Senate confirmation is required, and potentially more public debate about their suitability for roles involving foreign policy, intelligence oversight, or national security. So given all these changes, what should you actually do to prepare? Let me give you a comprehensive action plan. First and most important, stay informed through official channels. Immigration law and tax regulations are incredibly complex and they're constantly evolving. You cannot afford to rely on random social media posts, secondhand information from friends, or general advice that might not apply to your specific situation. Go directly to the official sources. The State Department's website provides authoritative information about passport and citizenship matters. The USCIS website is your resource for immigration-related questions. The IRS website, especially the sections dealing with international taxpayers and FATCA, will give you the most current information about your tax obligations. You should sign up for email alerts from these agencies if they offer them. Also, follow their official social media accounts. Many of these agencies issue regular bulletins or newsletters for Americans living abroad. Honestly, it's a good idea to make it a habit to check these sources regularly, maybe once a month, so you're never caught off guard by new requirements or deadlines. Second, get professional help. I cannot stress this enough. If you currently have dual citizenship or you're seriously considering applying for citizenship in another country, you really need to consult with qualified professionals who specialize in this complex area. On the immigration side, look for an attorney who focuses on citizenship matters and has specific experience with dual nationality issues. Make sure they're licensed to practice immigration law and are in good standing with their state bar. It's important to check their credentials, read reviews, and ideally get recommendations from others who've worked with them. On the tax side, you'll want a specialist in international taxation. Ideally, someone who's either a certified public accountant with international expertise or an enrolled agent authorized to practice before the IRS. Even better is finding someone who understands the tax systems of both the United States and your other country of citizenship. These professionals can help you navigate the complex interaction between two tax systems, spot potential problems before they become serious, and structure your financial affairs in ways that maintain compliance while minimizing your overall tax burden legally. Yes, these professionals cost money. Good immigration attorneys and international tax specialists are not cheap, but think of it as insurance. The cost of getting professional advice is a tiny fraction of what you might pay in penalties, legal fees, or lost opportunities if you make mistakes handling these matters yourself. One significant error in your tax reporting could result in penalties that far exceed what you would have paid for proper professional guidance from the start. Third, organize your documentation. This is tedious, unglamorous work, but it's absolutely critical. Create a comprehensive file, either physical or digital, with secure backups, containing all your important citizenship and immigration documents. This includes your United States passport, current and expired, your foreign passport, current and any previous ones, your birth certificate, preferably an official certified copy, naturalization certificate if you became a United States citizen through naturalization, any certificates of citizenship or consular reports of birth abroad, if relevant to your situation. On the tax front, maintain organized records of all your tax returns for at least 7 years, which is longer than the IRS typically goes back but provides a safety margin. Keep documentation of all foreign accounts, including bank statements, investment statements, and year-end summaries. Save records of any foreign real estate you own, including purchase documents, mortgage papers, rental income records, and property tax payments. Document any foreign business interests with incorporation papers, ownership agreements, and financial statements. Also, maintain records that demonstrate your ties to the United States. This might include evidence of United States property ownership, lease agreements if you rent in the United States, utility bills showing United States residence, employment records from United States employers, evidence of United States bank accounts and financial relationships, records of professional licenses held in the United States, and anything else that demonstrates your ongoing connection to America. Fourth, if you're considering applying for dual citizenship in the future, take time to carefully evaluate the decision. Dual citizenship offers significant benefits, there's no question about that. Enhanced travel freedom is a major advantage, with many second passports providing visa-free access to countries that are difficult for United States citizens to visit. Cultural connections become deeper when you hold formal citizenship, rather than just visiting as a foreigner. Business opportunities can expand significantly, as citizenship often provides the right to own property, start companies, and work without restrictions in your second country. Access to education systems can be valuable, particularly in countries with low-cost or free university education for citizens. Healthcare access is another consideration, as citizenship often provides access to national health systems that might be unavailable to foreigners. But these benefits come with increased responsibilities, and those responsibilities are about to become more demanding. You'll have tax obligations in potentially 2 countries, which creates complexity and compliance costs. You'll face more stringent reporting requirements to the United States government about your foreign activities, assets, and connections. You might encounter limitations on your career options, particularly in government service or sensitive private sector positions. You could face practical complications with passport renewals, security clearances, or travel to certain countries. Before you move forward with acquiring a second citizenship, really think through whether the benefits outweigh these increased burdens in your specific circumstances. For some people, the advantages clearly justify the extra complexity. For others, particularly those with simpler life situations and no strong need for a second passport, it might make sense to maintain your current single citizenship status.